A major shift is coming to workplace policies in British Columbia, and it's shaking up the way employers handle employee sick leave. But here's where it gets controversial. Under the new Bill 11, many businesses will no longer be able to demand medical notes for short-term absences related to health issues. This raises big questions. How will companies verify genuine illness? What happens to workplace safety? And who bears the cost of potential abuse? Let's dive in. Chapter 1. The Big Picture. Why this matters now. On May 29, 2025, British Columbia's legislature passed Bill 11, a sweeping amendment to the Employment Standards Act. The law aims to reduce the burden on both employees and healthcare providers by limiting when employers can ask for medical documentation. The government plans to roll out this change before the 2025 respiratory illness season, with the goal of freeing up 180,000 physician hours annually. Think of it as a win for employees struggling to get timely sick notes and a test of how companies adapt to less paperwork. #Key changes: what employers can't ask for. Bill 11 bans employers from requesting a specified health record for short-term health-related absences. Here's what that means in plain language. Specified health record: any document from a healthcare provider confirming an employee's illness, like a sick note. Health-related leave: time off due to personal illness, injury, or medical condition. Specified circumstances: these details will be finalized later through public consultation. But until then, employers must assume any multi-day absence, repeated or not, could fall under the ban. And this is the part most people miss. The law doesn't eliminate all proof requirements. Employers can still ask for reasonable alternatives, such as written statements from employees confirming they're unwell or receipts showing they purchased medication. It's a balancing act between trust and verification, unanswered questions, where the rub is. While the intent of Bill 11 is clear, several gray areas remain. Let's unpack them. First, duty to accommodate versus privacy rights. Under the BC Human Rights Code, employers must accommodate employees with disabilities or chronic conditions. But here's the rub. If an employee's recurring absences hint at a deeper medical issue, can employers still request notes to fulfill their legal duty to accommodate? Bill 11 doesn't clarify this, leaving room for conflict. Should the law prioritize privacy over fairness and accommodation? Share your thoughts in the comments. 2. Safety-sensitive jobs and liability. Imagine a construction worker returning after a week-long absence. If they're still unwell, their job could pose risks to others. But under Bill 11, employers might be blocked from asking for a doctor's note to confirm fitness for duty. Should safety override the law? Or is there a middle ground where exceptions apply to high-risk roles? 3. Extended sick leave benefits. Some companies offer generous leave policies beyond legal requirements. Without medical proof, these programs risk misuse, like employees taking extended unpaid leave and cashing in later. Should Bill 11 allow exceptions for employers who fund these perks? 4. Unionized workplaces. Collective agreements often outline when medical notes are required. Bill 11's silence on unionized environments creates confusion. Will negotiated contracts take precedence, or does the law override existing terms? This could spark heated debates between unions and management. What employers should do now, until regulations are finalized? BC employers need to act proactively. Revise attendance policies to accept alternative proof, e.g., self-attestations, medication receipts. Train managers to handle absences without relying on medical notes. Consult legal experts to navigate the overlap between Bill 11, the Human Rights Code, and collective agreements. The key takeaway? Compliance isn't just about avoiding fines. It's about building trust and ensuring safety. As one HR leader put it, this law forces us to rethink our relationship with employees. It's not about policing illness. It's about fostering responsibility. Still unsure how to adapt? Reach out to employment law specialists like Andrea Rasso, Ty Bradford, or the Employment Labor Group at C. Wilson. The clock is ticking, and clarity is just a conversation away. What do you think? Is Bill 11 a step forward for employee rights, or a recipe for chaos in the workplace? Sound off below.